Good morning.
Morning.
What are things like there in Carbondale? I'm in Philadelphia where it's sort of cold and breezy. What about, is it getting warming up back there? Or is anybody in Carbondale? Hmm. Okay, well, let's get started. Um, so does anyone have anything to bring to class as uh, equality under the law in the news?
Yeah, I was actually going through CNN. Like there was
Can you
another.
hear me?
Yes, yes, I can now.
Okay, now I can't hear you. Hold on. I'm having issues.
You can't hear me, huh? Hmm.
And now I can't hear you again. I don't know what's happening.
What about Haas and Tony? Can you hear me?
Yeah, I think she's just having issues with her mic. She said it a little earlier.
Well, I just hit the ask to unmute button. I don't know if that worked or not. Well, I'll tell you what, while she's playing with her microphone and trying to adjust it, Hasa, why don't you go ahead with what it was that you saw in the news?
Yeah, I mean it's more about the firings that Trump has been doing. The report is titled "The U.S. Economy Added 151,000 Jobs Last Month, and the Unemployment Rate Rose to 4.1%." I mean, apart from the usual things that it said about jobs being reduced, I found one thing interesting. Elon Musk was saying that he wants to privatize some agencies, I guess, so that I don't know. Like one of the things he said to privatize is the U.S. Postal Service. So I think
Right.
yeah, like I think what the government is trying to say is, especially Elon Musk is trying to say is that the government agencies aren't performing very well, so there's a need to privatize them. But then um I think that way the jobs won't be as like they won't be permanent as they used to, I guess, because government jobs like they don't fire you unless there's like a very good reason. So I think that will create more issues rather than solve problems.
Right. Well, it could well. I mean, I think you mentioned the jobs report, which isn't exactly under our umbrella, but I think that I mean, today's jobs report was pretty positive about the number of jobs added, but it didn't include the period of time when all these government firings have occurred. And I think there's been maybe somewhere in the neighborhood of 60,000 plus people, federal workers who have been fired. And that will begin to show up. Although I did see a story that said that the department that compiles the jobs numbers was thinking about excluding federal employment because federal employment's different than private employment as far as an indicator of the economy's health. Uh, Sort of playing with the numbers. Um, so I think we'll see the impact of these federal worker firings next month in the jobs report and going forward. Stock market's been in free fall. I think it was supposed to go up today, but it's had three really bad sessions because of all the uncertainty about the economy that has been created. Um, Other observations of things going on in the news that involve equality.
Okay, can you hear me now?
Yes, I can.
Okay, I have no
Yay.
idea what was said because I couldn't hear any of you. What was the news that Hafsa shared?
She was talking about the jobs report, that was sort of a big news story today. The economy added about, I don't know, 150,000. I didn't actually read how many zeros were there. New jobs, which is about, it's a fairly strong jobs report, but it didn't include any of the federal government firings that have occurred, because the survey was taken the week before the firings occurred. So we'll see what the next job numbers show. The economy seems to be um, troubled because of all the back and forth and uncertainty that Donald Trump is creating in Washington, with tariffs on, tariffs off, tariffs on, tariffs off. Um, so we'll see how that plays out. There was I noticed that I don't know if any of you saw this on your. I actually only saw this on my TikTok social media feed, although I know this to be a a true story, because I've also seen some of the law professors on my con law listserv talking about it. There's been some right wing backlash towards Amy Coney Barrett, uh, with right wingers calling her a diversity hire because she was the deciding fifth vote in a Supreme Court action. I think it was on Tuesday or Wednesday, um, the day after the State of Union speech. So it was Wednesday. Uh, that said, that Trump couldn't stop the enforcement of, couldn't stop the payment of money that had been committed by the U.S. Agency for International Development. It was a 5-4 decision by the Supreme Court. And even though that doesn't affect the interpretation of any uh, equality provision in the Constitution, it certainly affects a lot of U.S. government programs to aid people in less fortunate parts of the world, where there are HIV/AIDS programs in Africa that actually were set up by George W. Bush towards the end of his term, um, and really all around the world, where USAID has been active. Um, so that decision of the Supreme Court's was significant. Um, and it may foretell a 5-4 split on the court, on some of the more extreme actions that Trump takes. In the night of the State of the Union speech, as Trump went past Chief Justice Roberts, he thanked him apparently for the absolute immunity decision of last spring, last summer. And of course, Robert, it's probably the last thing in the world that Roberts wanted to be picked up on a hot mic, because it just has, led to more sort of critique of what he of that decision, um, which I also think was a poor decision. I had an interesting in raising money for the journalism review I publish. I invited Linda Greenhouse, who's a New York Times Supreme Court reporter, to come give us a talk in St. Louis. And one of the things Linda is about the best. She won a Pulitzer Prize for her Supreme Court reporting. And one of the things that she said that I thought was sort of interesting was that it was her understanding that Chief Justice Roberts was sort of shocked that there was so much pushback to his and criticism of his decision last spring to recognize absolute immunity for a president when for actions, for official actions taken. Um, yeah, because I mean that decision to his, I'm sure he pointed to the fact that his decision said no one is above the law and the president's not above the law. But then he made so many exceptions to that rule that he might as well not have said it. But it was interesting that Linda, who generally is more on the progressive side of things, but who has a good pipeline to the court, has been told that the Chief Justice was um, sort of upset at all the pushback and thought his decision was being read too broadly. And so for Trump to come up in front of the world on a hot mic say thanks a lot is the last thing that Roberts, who wants to try to protect the legitimacy of the court, um, that he has been the Chief Justice of for 20 years and probably will be the Chief Justice of for 20 more. Uh, uh, since legitimacy is the most important thing to him, that's the last thing he wants to have happen. So in this decision I was just talking about from Wednesday, uh, on uh, on basically curbing Trump's power to cut USAID funds that have been committed. Um, it was a 5-4 decision. Amy Coney Barrett was the other conservative who joined the 3 Democratic appointees, Kagan, Sotomayor, and Jackson. And if that lineup holds up on other cases involving Trump's uh, broad interpretation of executive power, then that'll be significant. So that's part of the reason there was backlash regarding Amy Coney Barrett, who had been appointed by Trump. And as a matter of fact, I could read you a. Let me see if I can find this real quick in my email. I was just reading it before we started class. It was a comment by a former um, a comment by a former Supreme Court clerk. You know, the clerks are the young law school grads, very sharp young law school grads picked by their justices to work in their office and help, who draft quite a few opinions. And um, one of the clerks said that was very critical of Amy Coney Barrett and said it was just she had just been a diversity hire. The clerk was, his last name is Davis. Let's see. Conservative allies of President Trump called Amy Coney Barrett evil and a closet Democrat and a DE hire after this decision was announced. On podcasts and social media, conservative allies of President Trump called the former law professor and appeals court judge evil, a closet Democrat, and DEI hire. Barrett and Chief Justice Roberts were the 2 conservatives joining the liberals in backing a federal court order that requires the administration to begin repaying global health groups nearly $2 billion for completed work.
So do these people even like hear themselves?
I
Like when
think
they talk, do they hear themselves?
I'm not sure that they do. She is evil. This is a quote. She is evil, chosen solely because she checked the identity politics box. Conservative activist Mike Cernovich posted on X, suggesting Barrett was put on the bench because she was a woman. Another DEI hire. It always ends badly. And then Mike Davis, a former law clerk for Gorsuch, said on Steve Bannon's podcast, Steve Bannon is the former Trump aide who's been convicted for a couple of crimes, but is still out there broadcasting, said she's a rattled law professor with her head up her ass. And apparently, this former clerk has previously said that Americans should, quote, arm up against the black underclass. So not a very strong advocate for equal rights.
So basically, DEI is anybody who's not a white man, right? Got it.
Yes, I believe I believe that is accurate. I have a former student who's now a PhD. She was a former PhD student of mine, and she actually worked in the Daily Egyptian as a grad student, and she now teaches at North Carolina Coastal Journalism School, and one of her classes is gender studies in communications. And her dean told her last week that she's going to have to change the name of the course and to remove the word gender. And because they don't want to attract attention from President Trump or his supporters in North Carolina. And I mean, that kind of reaction on the part of nominally intelligent people. A dean should have had enough education to not be saying something so ridiculous. I mean, the thing that the broad misunderstanding of this whole DEI question is what the Supreme Court decided in the affirmative action admissions case involving Harvard and North Carolina was that you couldn't have an affirmative action program that had a discriminatory effect upon any particular groups because of their race. And in that case, Asian American students in particular had been discriminated against I mean, they filed a lawsuit. So for DEI to not be legal for diversity, for an institutional effort to create diversity, equity, and inclusion, for that to run afoul of the law, there has to be some discrimination against somebody. Naming a course, gender studies in communications, does not discriminate against anyone. And where there's not discrimination in violation of the Equal Protection Clause of the 14th Amendment, there's no problem. It's within the prerogative of the professor and the higher institution of higher learning, whether it's getting federal money or not, to decide that they want to have a class in gender studies and communications. It's within the academic freedom protected by the First Amendment. I mean, if my friend Wendy decided that if she refused, for example, to change the name of the course because she said it was interfering with her First Amendment right to decide the content of her course, and was content-based discrimination. If she and if she were punished in any way for pushing back in that manner, if she were fired, for example, or demoted, or not giving a promotion, that would be discrimination, and against her First Amendment rights, and she would be able to file a lawsuit. So people are very much misunderstanding the DEI, and that's because President Trump is wielding it as such a broad, you know, in such a broad way.
Feel
Um,
like Trump only does this to keep his voters happy.
well, yeah, and I think it makes him happy to just be, you know, be appearing to make lots of changes. You know, I mean, let's be honest. The whole idea of a woke you know, this sort of attack on wokeness, it that is popular. The attack on wokeness is popular. Wokeness is not popular, and so he is playing to a vast majority of uh, a vast majority of Americans when he attacks things that are perceived to be woke, as is diversity, equity, and inclusion. And and I mean, I can tell you from my personal friends who are, you know, active in public affairs and who are liberal Democrats, they are they're not going to defend any kind of you know, wokeness. They feel as though liberals went way too far in that regard. So I think I think President Trump is has correctly perceived that most Americans, most of the American people are anti-woke, and so he's playing to a very popular position. Now, when it results in these ridiculous over reactions like I'm talking about here, or like today, there's an AP story saying, this is in today's news, March 7th, AP, the Pentagon's latest DEI purge targets images of war heroes and military firsts. Elon Musk tells lawmakers, uh, um, let's see here, let me read that story. References to World War II. Um, just getting the story up. References to World War II Medal of Honor recipient, the Enola Gay aircraft that dropped the atomic bomb on Japan, and the first women to pass Marine infantry training are among the tens of thousands of photos and online posts marked for deletion as the Department of Justice purges diversity, equity, and inclusion content, according to a database obtained by the Associated Press. Um, the database which was confirmed by the U.S. officials and published by AP, includes more than 26,000 images that have been flagged for removal across every military branch, but the eventual total may be much higher. Um, I remember seeing that amongst the things that had been removed were pictures of the Tuskegee Airmen. As many as 100,000 images or posts in total are being considered for deletion. Um, the vast majority targets women and minorities, including notable milestones in the military. It removes a number of posts that mention various commemorative months, such as those for Black, Hispanics, and women. There's a picture, for example, of Black soldiers at Chanute Field in Illinois during World War II, um, undergoing ground training. That's one of the things that was cut out. Um, Picture of airman who's black. I'll send you I'll put this in the chat. So I mean, this is the kind of, I mean, when I say overreaction, there when the Trump administration says DEI is discriminatory, there's nothing about including these images in public government databases that's discriminatory. And so to just eliminate anything that has women, blacks, or Hispanics in it is absurd. Yeah, I'm having trouble. Let me get the Let me get the link and put it in there. Because it has some of the pictures that are proposed for removal. Chat. There we go. I want to say one other thing about the Supreme Court decision from last week, where that went against Trump 5-4. It was very significant because it may indicate a lineup of justices who are going to put at least some guardrails on what the president does. But it shouldn't be overinterpreted. For one thing, it is, and I read a number of law professors who said this yesterday, that they were amazed that there were 4 justices. This is Gorsuch, Kavanaugh, Thomas, and Alito, who said that who were on the other side, dissented. And they were basically arguing that the courts were exceeding their power in keeping the president from blocking the payment of USAID obligations that already had been, that USAID had already committed to, contracts they already had, services that had already been rendered. So in other words, this case was about as good a case for those challenging Trump as any that could come along. The day after this case, I think on, or maybe the same day, actually, the DC Federal Court of Appeals ruled in favor of Trump, and saying that the special counsel, I think his name is Dellinger, the special counsel who protects, who was fired by Trump, whose job it is to protect whistleblowers and other government employees, that the courts shouldn't have the power to block Trump's removal of the special counsel, even though Congress said there had to be 30 days notice in prior, and there had to be cause given for removal, which Trump did not do. So that's an indication that, and then Trump fired Dellinger, and Dellinger gave up his legal challenge. So the Supreme Court action in the USAID case is significant, but it's not definitive about what will happen going forward. There are a lot of justices on the Supreme Court who believe in a unitary executive, and think that a lot of the 8 independent agencies set up by Congress since the New Deal, for example, the Consumer Product Safety Commission, or the FCC or the FTC, that a lot of these agencies that the president should be able to fire anybody in those agencies with no limits on that firing power, because the president is in charge under the Constitution, is in charge of the executive branch. And these agencies, even though set up by Congress, are agencies that are in the executive branch. So it could well be that either Roberts or Amy Coney Barrett, or both, in a future case that was not so clear cut as this one they acted on Wednesday, might come down on the other side. Anything else in the news? What did y'all think of the State of the Union speech?
I refuse to watch it, but I do have an article that I was going to share at the beginning of class, but my stuff wasn't working. If you
okay, yeah, shoot,
want to hear it,
go ahead.
I picked out the one where Donald Trump said that he's going to stop funding for colleges that allow illegal protests, and said
Oh,
that
yeah.
American students will be permanently expelled or, depending on the crime, arrested. He posted that on Truth Social about that statement. And
You
I'm
know,
like, illegal protests?
he posted that, I would just point out, the day after I think it was the day after he had posted on True Social that he has brought free speech back to colleges and the country.
Yeah.
Yet, what you just read is a flat out violation of the First Amendment.
Right.
The First Amendment um, requirements regarding, like pro Gaza protests on college campus are complicated. Um, but you certainly can't go as far as Trump went to say if anybody goes out to participate in these protests, they can be arrested and kicked out of school and deported. I mean, that's ridiculous. The reason I say it's complicated is that, I mean, if a where there is where as in many of the pro Gaza demonstrations, there are encampments set up on college campuses or in communities, protest encampments. Universities have every right to declare those to be against university regulations, or local municipalities can declare them to be a violation of city or state ordinances and arrest the people who are doing it. And that's because the First Amendment does not protect anybody against reasonable time, place, and manner restrictions. And universities and municipalities have every right to set up, um, to say encampments are interfering with the learning environment of the university, of blocking students' access to various university facilities, and or violate health and safety regulations or laws. And so also, uh, protests in favor of, it's sort of important whether or not the protest is couched as a protest in favor of Hamas or in favor of the Palestinians living in Gaza, even though in many cases it may be the same. I mean, Hamas has been declared to be a terrorist organization by the U.S. government as well as most Western governments, and it has richly earned its designation through many terrorist attacks. The horrible attack of October 7th being a prime example of that, which involved taking hostages and murdering civilians and sexually attacking women. Um, so they have richly earned their designation as terrorists. Uh, giving material support to a terrorist group is illegal. So, for example, if you had a college protest that was organized to raise money for Palestinians and the money was being funneled through a Hamas affiliated organization, that would most likely be a violation of federal law. So I'm just saying one can't say Trump's True Social post was offensive to the First Amendment and went way too far. But there are the protests at colleges are susceptible to being regulated by the college campuses in the ways I just described.
Professor, that actually reminds me, like in your law class, we did read about a protest about encampments. So that decision said that encampments aren't allowed outside the university, right?
They aren't allowed at a university or outside of I mean, if an encampment is set up in a way in which it violates a campus regulation on a college campus or if it violates a municipal law that says, you can't have overnight encampments um, because they violate health, safety, and health and public safety laws, which are generally applicable laws that apply regardless of what the ideological content of the protest is, then those laws can be enforced against the encampment and the people can be arrested. Um, there was an encampment like this at Washington University in St. Louis, and um, the university organized the people to, and the local authorities arrested all the people, and the university kicked a lot of them out of school. So go ahead, Hafsa. Were you going to say something more about that?
Yeah, I mean, if people want to protest, how do they protest? Social media, or do they wear like armbands, or how?
Wear armbands or hold a protest rally and, public a public portion of public, like a portion of the university that's used, that's often used for, it's like a public forum. Maybe it's the maybe it's a mall or a plaza or a central, a quadrangle of the university or a public park. Public spaces that are often used as forums for protest. So there are plenty of First Amendment protected ways in which one can protest and support Palestinians or support the Israelis. Even probably you could, I mean, I believe that you would be protected, although this would get a little bit closer, but I think a protester in one of these protected places like a quadrangle, a university quadrangle at a peaceful protest, who had a sign that said, support Hamas because they protect the Palestinian people. I think even though it would be saying to support a terrorist group, that would be protected speech. Although, as I say, the university could try to, or municipal officials in the surrounding community could try to enforce some sort of discipline against that. I mean, the area where it, one way in which it gets complicated beyond what I've already described about encampments is that if the speech at the protests is on college campuses is hate speech. And, makes Jewish students feel as though they are unsafe, or vice versa, makes Palestinian students feel as though they are being targeted because they are Palestinians or Muslims or whatever, based upon those kinds of characteristics. Then if it said, if you had a very sort of boisterous rally, all against targeting Jewish students or targeting Palestinian students, then that would create a hostile learning environment and would interfere with the civil rights of the students who were targeted by the protest speech.
Professor?
Yeah, go ahead.
No, I was just like saying that I know that it might sound like I do remember most of the stuff we studied in the law class and everything. It's just that like I just feel like aside from the Palestinian and Israel issue, I feel like there's some things that like the government tries to censor most than others. Like I mean, there are times when the lines have blurred, basically. During the Black Lives Matter movement in 2020, people were being persecuted for protesting against the decision made by the judges in the George Floyd case. So like I feel like there are times when like it's true that our First Amendment does get protected, but there are times when the lines get blurred at even though the police, persecuted those people, there were times when the government said that that's okay, like those people were causing disruption, even though those people, most of them weren't causing disruption. They were just peacefully protesting.
Yeah, well, I'm going to put in the I'm going to put in the chat a story that a former student of mine. I don't think any of you were around for her being around. Callie Cox is her name, and she was head of the editor of the Daily Egyptian, and she wrote this story for me last fall at the time of these Palestinian demonstrations, and it quotes a law professor buddy of mine, Greg Majarian, who's a First Amendment expert at Washington University, saying that the university enforcement of these kind of campus speech rules has been very much directed against Palestinians, and he refers to this as being like a Palestinian exception to the First Amendment that he analogizes to the McCarthy era, early 1950s sort of exception for communist uh, party leaders that the Supreme Court uh, read into the First Amendment. Greg Majarian, a First Amendment expert, blah, 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 says difficult to escape the conclusion that there's a Palestinian exception to free speech. This is a quote from him. What we've observed with these Palestine protests measured against any norm of free speech in the case of public universities, the First Amendment protection, is something I've rarely seen before. You've got congressional committees browbeating and driving out of their jobs university presidents for the sin of not punishing students who say things like, "From the river to the sea, Palestine will be free." The notion that the slogan is outside the First Amendment's protection or outside ordinary norms of free speech is a completely crazy notion that is textbook day one free speech stuff. If someone is out on the street yelling, "Kill all the Jews," that's a different conversation. This exception is creating a new wave of McCarthyism, as too many people are deliberately attempting to weaponize false connections between dissent and terrorism, he said. In addition to the term terrorist and instead of the label of communist, in addition to the term terrorist and instead of the label of communist, critics are calling pro-Palestinian speech and criticism of Israel as anti-Semitism. There's a quote, there's a lot of rhetoric from certain segments of the people who support Israel saying, if you're participating in these protests, you're a terrorist, or if you're a supporter, or you are a supporter of terrorists. That is the functionally identical to being in the 1950s and saying, if you are expressing commitments to any kind of social or economic egalitarianism, you are a communist. So, I mean, I think that sort of backs up what I thought I was hearing you saying, Hafsa. Maybe I'm putting words in your mouth. If I am, I don't mean to. But I think Majarian is basically right on that there's a lot more political pressure to enforce student speech rules against Palestinians because the Jewish voters are much more powerful in the electorate.
Yeah, that aligns with what I was saying. Like some opinions get more backlash than others. Uh, First Amendment is protected in many cases, and like the law does protect people who are protesting. But there are just times when they focus more on the message than on the way it's being protested, and then they arrest people or fine them or whatever.
Right, right. Anybody have anything else about that's in the news they were wanting to bring in? By the way, I haven't given anybody any credit today. Let me do that while anybody else says what they want to say. Anybody else have anything in the news? Does everybody agree with Trump that he's the greatest president in history?
Vomit. Whoops. Did I say that out loud?
What's that?
I said vomit, and then I said, whoops. Did I say that out
Yeah,
loud?
yes, you did say that out loud.
Just so you know, I don't know if you saw it in the chat, but I have to leave about 20 minutes before the end of class today.
Oh, okay, okay.
So if you want to take away my points, you can.
I'll see if we can't, if I can stop yammering on and get because I'd like to be able to review for the test before people have to start leaving. Does anybody have to leave sooner than that? I'm giving you guys your credit here. So we'll move a little bit more quickly. Actually, there's quite a bit of, let's see, there's Tony. Let me get you. Okay, I think I've got you all. Okay, so let me turn to so I'm gonna just like present this pretty fast. This sort of look at Reconstruction and the 13th, 14th, and 15th Amendments. And we will also, I also would like to talk about the some of the wars against Native Americans and the hanging, the largest execution in history of Native Americans in Minnesota, and touch on the whole concept of manifest destiny, Frederick Jackson Turner's theory about the importance of the movement to the West in American history as being a defining dynamic of American history, and certainly that is true. Manifest destiny, of course, goes much farther to say it's God told us, God gave us the right to do it. It's a settlers' a God-given destiny to move west and settle and create a life for themselves. And I mean, I have to say that it's hard for me to be startled by Donald Trump, but when he said in the State of the Union speech, again reiterated manifest destiny, a doctrine that I thought had died somewhere around 1900, as being alive and well, I was fairly shocked. Of course, he also said in his State of the Union speech that God saved him from the assassination attempt so he could save America, or words to that effect. Okay, so we're gonna start here with the 13th, 14th, and 15th Amendments. So they were all added to the Constitution after after the Civil War, and the 13th Amendment, and they together are like a constitutional, like a second constitutional convention in a way, or a second major, a major change in the Constitution post 1787 that's almost as significant as the Constitutional Convention itself. So you have the Constitution, the original Constitution of 1787 doesn't have the Bill of Rights, doesn't have equality, and Bill of Rights is added within 4 years. Now here we are after the Civil War, and on the basis of the Civil War, 13th, 14th, and 15th Amendments are added. 13th Amendment banning slavery. Up to this point, remember that the Emancipation Proclamation, which even Lincoln thought might be unconstitutional, only banned slavery in the rebelling territories. So it actually didn't ban slavery anywhere where the Union armies were in control. So it didn't actually ban anybody's slavery. But the 13th Amendment solved that and ended the institution of slavery. 14th Amendment, this is as I think I've said several times, this is the powerhouse of of the Constitution. It barred states from denying people liberty and equality, and so the two most important phrases in the 14th Amendment are liberty protected by due process of law. That's also usually referred to as a due process clause, and equal protection under the law, equal protection clause, which was the first time equality was injected into the Constitution. Oftentimes those two clauses are interpreted together, as together forming rights that are not specifically enumerated in the Constitution. The due process clause, the liberty protected by due process, is what was the basis of the Supreme Court in the 20th century applying most of the Bill of Rights to the states. In other words, the liberties named in the Bill of Rights are protected, are amongst the liberties protected by due process of law from state interference. We'll see that in the years right after the Civil War, equal protection is given a very sort of narrow interpretation, not applying to women, not requiring desegregation, and it wasn't until the Warren Court of the 1960s and 70s, Brown versus Board of Education, Loving versus Virginia, etc., that the Equal Protection Clause began to take on a much broader significance. 15th Amendment protected voting rights, but the Supreme Court immediately read most of that out. So like the Declaration of Independence and the Constitution, the broad promises were immediately read out by the Supreme Court. The sponsor of the 14th Amendment, who was James Wilson from Iowa, said that equal protection did not mean, quote, that in all things civil, social, political, all citizens without distinction of race or color shall be equal. Nor does it mean that all citizens shall sit on juries or that their children shall attend the same schools. As a matter of fact, the Congress of that day, the Congress that approved the 14th Amendment, ran segregated schools in the District of Columbia, and so clearly did not think that violated the 14th Amendment. Nobody at the time of the framing of the 14th Amendment thought it applied that the persons included women. So over the next 40 years, the Supreme Court gutted and perverted the post-Civil War amendments. The court said the 14th and 15th Amendments did not give blacks the right to vote or to live in an integrated society alongside whites. The first key case, and by the way, when I refer to these cases, if you have read any of these cases in doing the readings for the course and you want to present them instead of me, please interrupt me and go for it. The cases to really know about are the 1873 Slaughterhouse. Oh, I want to say one more thing about the enactment of the 14th Amendment. I think I mentioned this at the end of our class last week. The 14th Amendment was only ratified because the South had to agree to ratify, the southern states to be admitted to the Union had to agree to ratify the 14th Amendment. I'm afraid if we ever had a new constitutional convention, we wouldn't have any 14th Amendment. So, first case, 1873, the slaughterhouse cases. The court said that the 14th Amendment gave freedmen the rights of national citizenship, but not the rights of state citizenship. 3 years later, the court said the 15th Amendment, the suffrage amendment, quote, does not confer the right of suffrage upon anyone. I mean, they flat out said that, even though the amendment itself says the rights of citizens of the United States to vote shall not be denied on account of race, color, or previous condition of servitude. So the distinction they're making is, states decide who gets to vote. So citizens of the United States, yeah, they've got the right to vote, but it's the states who decide who gets to vote, and the states are not covered by the 15th Amendment. Civil rights cases of 1883 grew out of the refusal of inns in Jefferson City, Missouri, and Kansas to provide lodging for blacks. A train conductor's refusal to let a black woman into the ladies' car of a train. Theater owners in New York and San Francisco refusing to sell seats to blacks. The court concluded the 14th Amendment's equality guarantee did not permit Congress to reach quote unquote private discrimination. That would be an invasion of individual rights. This is an important limitation on the 14th Amendment, is there has to be some form of state action. When we get to the late 1940s and the restrictive real estate covenants that existed in St. Louis and many other states around cities and states around the country, we'll see how the Supreme Court gets around that the state requirement. Let's see here, and then came Plessy versus Ferguson, the 1896 decision that upheld Louisiana's denial of a seat on a white railroad car to Homer Plessy, who was 1/8 black. I think it was referred to as people who had that amount of black blood, maybe an octoon. I could be wrong about that. Don't hold me to it. It won't be on the test. But yeah, there was this doctrine in the South that one drop of black blood, and you were black. So 1/8 was plenty to deny him access to the railroad car. Plessy versus Ferguson, 1896, enshrined separate but equal as the meaning of equal protection in the 14th Amendment. And that stood for 58 years until Brown versus Board of Education overturned it, explicitly overturned it. The court said in Plessy, that the 14th Amendment, quote, could not have been intended to abolish distinctions based upon color or to enforce social as distinguished from political equality, or a commingling of the two races upon terms unsatisfactory to either. You notice that either, there's this constant refrain from these racist decisions of the Supreme Court that this is what black people want too. If one race can be inferior to the other socially, the Constitution cannot put them on the same plane, wrote Judge Henry Billings Brown. Justice John Marshall Harlan was the lone dissenter. He wrote that, quote, the white race deems itself to be the dominant race in this country, And so it is in prestige and achievements, in education and wealth and in power. But in view of the Constitution, in the eyes of the law, there is in this country no superior, dominant, or ruling class of citizens. There is no caste here. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect to civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. In my opinion, the judgment rendered today will in time prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case. And that was pretty much found out true. St. Louis schools, for example, were segregated until Brown versus Board. I mean, you're looking at a person who was I was in the first kindergarten class that went to desegregated schools in the city of St. Louis. Of course, my quote unquote desegregated schools only ever had one black student in the whole time I was there. By the way, Joe, I see you joined us. I'll make sure I give you credit. I'm running through the sort of important information in the involving equal justice before the law, or not equal justice before the law, in the Reconstruction era.
By the way, Professor, the lectures you just like read through, I posted comments on those. Like they were under the titles of discussions 3 and 4. I was just wondering if you checked them.
I check all. I get a note whenever anybody posts a discussion. I read the post, and I give you credit. I'm not saying that I sometimes don't miss, but I believe that I've given you. I've seen those posts and I've given you credit.
Okay, thank you. Just wanted to make sure that's all.
Okay. Okay. Let's see. I've got. I'm not gonna. I'm not gonna touch on some of this 20th century history where we get up to restrictive covenants and the East St. Louis race riot, because I don't believe that that is covered on the test, and we will talk about it later. The East St. Louis race riot was the biggest in 1917, was the biggest racial had the highest death toll up to that point of time. Tulsa may have surpassed it, in Los Angeles riots after the beating of Rodney King and the initial exoneration of the police who beat him, that surpassed the East St. Louis race riot. Let's see. Let's go through some of the 19th century legal history involving women and as it and particularly as it relates to whether they're covered by the Equal Protection Clause of the 14th Amendment. At the time of the Constitution was written, Dolly Madison's, or actually Abigail Adams wrote to her husband to remember the ladies. Well, she wrote on March 31, 1776, in the new code of laws, which I suppose will be necessary for you to make, I desire that you remember the ladies. We're determined to foment a rebellion and will not hold ourselves bound by any laws in which we have no voice or representation. John Adams, second president of the United States, and one of the founding fathers thought she was kidding, because it was it seemed so ridiculous at that time. I mean, if you put things in perspective, when the great grandmothers of today's young women were born, women couldn't vote. They were expected to be mothers and homemakers. When the grandmothers of today's young women were born, women had no protection against discrimination uh, in education, jobs, or obtaining credit. Uh, the Supreme Court at that point, and so we're talking about like 40s and 50s and 60s, said equal protection did not include women. Uh, I may have told you the story that when my wife tried to get a job as a young talented reporter in Boston, when I was trying to go get enough money to go to Harvard Law School, that she went to the Boston Globe and the editor said, "Why should I hire you? You'll just have babies." Of course, she did eventually we did have 4 children, but that was not against the law in 197 in September of 1971. And into the 1970s, women, public school teachers, female public school teachers who became pregnant were routinely fired because they thought it was a bad role model for the children. Of course, the women of today are coming of age when the legal rights for women, after many decades of advancement, uh, have been cut back with the Dobbs decision involving abortions and reproductive freedom. In the early 1800s, there was coverture and subservience. The subservient status of colonial women is sort of shocking when you think back on it. It was accepted without question by the framers of the Constitution, who didn't even debate it at the Constitutional Convention. Most Americans, for much of their history, were convinced that God and nature had decreed the two sexes inhabit different spheres and have different roles. Men's roles were public and political, women's were domestic. Through the 19th century and the 20th century, women's intellectual pursuits were widely believed to be improper. This is improper, physically harmful, and detrimental to motherhood and the perpetuation of the race. Thomas Jefferson hoped women would be, quote, contented to soothe and calm their minds. This is a soothe and calm the minds of their husbands, returning ruffled from political debate. Uh, the president said he quickly put an end a rumor he might appoint a woman to political office, an innovation for which the public is not prepared, nor am I, he said. In the antebellum days, in other words, before the Civil War, the progressive ideal of a woman was defined by Republican motherhood, influencing their husbands and educating their sons for public service. The ideal Republican mother was rational, self-reliant, and benevolent. Rules of coverture, derived from English common law, gave husband the right to the wife's paid and unpaid labor, most of her property, and her obedience. Wives couldn't sue or make contracts without their husband's consent, nor could they vote. In the eyes of the law, they were, quote, and this is quoting William Blackstone, the great 18th century legal commentator, very being or legal existence of women is suspended during marriage. In 1839, Mississippi enacted the first Married Women's Property Act, but it was mainly intended to give women continued control of slaves. Catherine Beecher traveled the country campaigning for a schoolhouse in every community and a woman in every schoolhouse. Male teachers, he noted, were often low, vulgar, obscene, intemperate, and bad teachers. And I think it is true that sort of women's school teachers was a real advancement for women in the 19th century. Women gathered at Seneca Falls in 1848 to write the Declaration of Sentiments, patterned after the Declaration of Independence, except they declared all men and women are created equal. Instead of laying out King George's tyrannies, it laid out the tyrannies of men, beginning with the refusal to allow women to vote or have any voice in lawmaking. Other grievances were discrimination in education, jobs, and pay, and the prevailing double standard of morality. Man, quote, has endeavored in every way that he could to destroy woman's confidence in her own powers, to lessen her self respect, and make her willing to lead a dependent and abject life. Elizabeth Cady Stanton wrote in a declaration that who wrote the Declaration hadn't always believed in a public role for women. She and her husband had attended a convention in London to discuss the abolition of slavery. The men at the convention debated while the women were allowed to join them. Uh, uh, the men at the convention debated whether the women should be allowed to join them, while the women were in a curtained gallery and forbidden to speak on the issue. She called that refined torture. That's when she met a Quaker preacher, Lucretia Mott from Philadelphia, and was astonished to see her speak to a group of men. The two decided to hold the Women's Convention in the United States, which became Seneca Falls. The press widely denounced the Seneca Falls Declaration. Some papers called the women Amazons, others criticized those seeking, quote, a petticoat empire. The Albany Advocate wrote the Declaration of Sentiments was a mere parody and added it requires no argument to prove that this is all wrong. Every true-hearted female will instantly feel that this is unwomanly. The 14th Amendment provided in 1868, no state shall interfere or shall make or enforce any law which shall abridge the privileges and immunities of citizens of the United States. No state shall deny any person any person within its jurisdiction equal protection of the laws. But when two women, one from Missouri and one from Illinois, went to the Supreme Court to claim the amendment's protection, they quickly found out they weren't included. Myra Bradwell had studied law in her husband's Chicago law office, ran a well-respected legal publication. The Illinois Supreme Court denied her the right to practice solely because she was a woman. She argued the privileges and immunities protected by the 14th Amendment included her right to pursue her profession. Her lawyer harkened back to the Declaration of Independence, quote, in pursuit of happiness, all vocations, all honors, all positions are alike open to everyone. In protection of these rights are equal before the law. There was no lawyer arguing the other side of the case. They thought it was so ridiculous, but Bradwell lost anyway. As the 1873 opinion put it of the Supreme Court, the civil law, as well as nature itself, has always recognized a wide difference in the respective spheres and destinies of man and woman. Man is or should be women's protector and defender. The natural and proper timidity and delicacy which belongs to the female sex evidently unfits it for many of the occupations of civil life. I'm still quoting. The harmony of the family institution is repugnant to the idea of a woman adopting a distinct and independent career from that of her husband. The paramount destiny and mission of woman are to fulfill noble and benign offices of life and mothers. This is the law of the Creator. Practicing law is a right that cannot be granted by a state, that can be granted by a state, not a privilege guaranteed by the Constitution. The next year, the Supreme Court turned away Virginia Minor, president of the Women's Suffrage Association of Missouri, who had tried to register to vote in St. Louis in 1872 but was denied. Chief Justice Morrison Waite wrote a unanimous opinion that there is no doubt that women may be citizens, but there is also no doubt that not all citizens of the United States can vote. It's up to the states to decide who has that right. And Missouri said no. If the law is wrong, it ought to be changed, the court said, but the power for that is not with us. Also, after the Civil War Anthony Comstock. And remember this because this could come up in the mifepristone and abortion debate. After the Civil War, Anthony Comstock crusaded against for the passage of laws against pornography, including provisions that he drafted himself, making contraception illegal. Soon, 24 states had passed laws outlawing contraceptives. Comstock believed that contraception caused lust and lewdness. Um, I'm not going to move on yet to the 20th century early 20th century cases on equal protection interpretation as it affects women. We'll talk about that later. There was a very paternalistic view the Supreme Court took that they were protecting women to keep them keep them out of the workforce. Okay, the one other area that I want to talk about is um, the execution of Native Americans in Minnesota. Let me get my materials for that. This was in 1862. Hold on a second. So if you didn't listen to the podcast, I think this podcast is called the whiteness seeing this particular podcast is called Seeing White, and this was in 1862. Mankato, Minnesota was the site of the largest mass execution in U.S. history, the hanging of 38 Dakota warriors. This had followed one of the major wars between the Plains Indians and the settlers. In this documentary that was produced for American Life, uh, uh, the events leading up to the execution and Lincoln's role in sparing most of the Dakota Native Americans who had been sentenced to be executed was discussed in this. We're going to have a separate class after the first test that we will devote to Manifest Destiny and Native American law, which we're going to have one of our students present. I'm trying to find the number of people who actually, seems to me it was about 300 people who had been sentenced to die, and that Lincoln spared all but the ones who were executed, the 38 Dakota warriors. That still made the largest mass execution in history. I just wanted to touch on that because I believe there is one question on the test that deals with it. As a matter of fact, the first question on the test. So I'm now going down, I'm looking at the test, which is available after the class. And the very first question asks you whether or not Lincoln, when he approved the largest mass execution in history in Minnesota of Native Americans, whether he commuted the death sentences of another 300 who had been sentenced. So that's something that you need to know. There's a question on critical race theory. We haven't actually talked about that too much in this class. I think we did a little bit at the beginning. I mean, critical race theory, the thing, all you need to really know about critical race theory, it's another one of these phrases that President Trump will oftentimes refer to. And critical race theory was developed, is sort of a specific, well, conservative criticism often says, well, critical race theory is being taught at universities and in schools across the country. Well, I mean, first of all, I think it would be the very exceptional high school program anywhere in the country that would touch on critical race theory. To the extent that it is a accepted theory. It was developed at Harvard Law School. It grew out of Marxist thought, which is one of the things that makes it controversial. I mean, the basic gist of it is that that race is that racial discrimination is over the history of the United States has been an institutional characteristic of the society and the government. And the current administration says that is not true. In their letter 2 Fridays ago to colleges around the country, they said that had been a perversion of U.S. history. Of course, as we're studying in this course, and as is evident in any fair portrayal of American history, there's been institutional racism in the United States that was first evident in slavery, and then in second-class citizenship by blacks, and then in segregated laws and the lynchings of the late 19th century and early 20th century, and in discrimination that persisted legally until the 1964 Civil Rights Act, and it's still persists today in just not explicitly in the law, but in customs. That's all you need to know about critical race theory for the test. 3/5 compromise. Just remember that the 3/5 compromise is, well, first of all, the word slavery is not used in the Constitution. And you'll recall that last week when we were talking, or 2 weeks ago, when we were talking about the Lincoln-Douglas debates, that Lincoln made a point of this in the Lincoln-Douglas debates, saying that the founding fathers didn't made a great effort to make sure that the word slavery was not in the Constitution, because they believed that slavery would eventually die out and sort of die of its own weight. The 3/5 compromise, though, turns up about 4 paragraphs into the Constitution, and just keep in mind that this did not give the right to vote to 3/5 of a vote to black to slaves. There was no vote for slaves. There were in both states there was no vote for free black people. The Three-Fifths Compromise, what it actually did was it gave more political power to the South because they got to count for apportionment purposes, uh, apportionment of representatives purposes, 3/5 of the slaves they owned as property, as part of their political power. I think I mentioned to you that but for the Three-Fifths Compromise, John Adams would have defeated Thomas Jefferson in the election of 1800. That's how much additional power was added to the Constitution on behalf of white Southerners. Manifest Destiny, remember that refers to the notion that God has ordained the white settlers movement west to settle the entire continent. Remember when we read the 1776 project that Trump had authorized to counter Nicole Hannah Jones' 1619 project, that the 1776 project says that identity politics is a rejection of the promise of equality in the Declaration of Independence, and the 1776 project even likened, so they were accusing the 1619 project of engaging in identity politics by stressing the importance of race as a central element of American history. And they said this was akin to the thought of John Calhoun, who was like the leading Southern segregationist from South Carolina, in a comparison that I'm not sure what they thought were the similarities. There's a question about the Bradwell and Minor cases we just talked about regarding equal rights of women under the 14th Amendment. They lost those cases. President Lincoln himself had doubts about the constitutionality of the Emancipation Proclamation. His argument in favor of having power was that it related to his power to make war, his war power, because it was he was announcing it during the he issued the Emancipation Proclamation January 1st, 1863, in the midst of the Civil War. Remember, we talked a lot about how even though Illinois is a slave state, people could still have slaves. They could subvert their freedom by pressuring them to be indentured servants. It was a place where a lot of slavers were hanging around cities like Alton on the Mississippi River, and white citizens in Illinois were supposed to stop blacks they saw on the street and make them present their freedom licenses. They didn't have them; they would be sold back into slavery. In the Lincoln-Douglas debates, remember that the central issue in that between Lincoln and Douglas was whether or not the Dred Scott decision was correct. I'm not sure I mentioned this, but keep in mind that the 1776 project that was that was conducted at Trump's request during his first term, that there were no noted historians who were involved. I'm not sure. You need to know that Jefferson, at the time the Missouri Compromise passed, remember that was in 1821. He called it a fire bell in the night, warning of civil war to come. Author of the Bill of Rights is James Madison. No equality guarantee in the 14th Amendment. There's an essay question where you're asked to explain why Abraham Lincoln was not an abolitionist through the end of 1862. Includes statements from the Lincoln and Douglas debates, the 1860 presidential campaign, and statements and actions during the first years of his presidency. At one point, if any, did he become a true abolitionist? Was it not until passage of the 13th Amendment in 1865, which he didn't even live to see ratified? That's the essay question. The Supreme Court, we were just talking about, read a lot of the meaning out of the 14th Amendment and the Equal Protection Clause in the post-Civil War era. Here's a little trick question that actually I had forgotten was on this test. At some point, George Washington, who, there's the apocryphal story about him cutting down the cherry tree and telling his father about it because he couldn't tell a lie. At some point, he referred to the Declaration of Independence's line about all men are created equal as being the golden apple. There's a matching section. The things to match are Lincoln, 13th Amendment. Well, let's see. Let me look at the other side. Roger Taney was author of the Dred Scott decision, Chief Justice. James Madison took notes and so Taney was really pretty infamous. Was very infamous for his writing of the Dred Scott decision that said that blacks, whether free or slave, had no rights that white people needed to abide by, and that blacks were just lucky they got saved by being brought to the United States. James Madison took notes on the Constitutional Convention and wrote the Bill of Rights. Emancipation Proclamation was written by Lincoln. Remember that Douglas's whole idea relating to spreading of slavery in the territories was popular sovereignty. In other words, the people in the territory should be able to choose, and so he was for getting rid of the Missouri Compromise, and in fact, the Missouri Compromise was declared unconstitutional by the Dred Scott decision for taking away people's property without due process of law for violating the Bill of Rights. Nicole Hannah-Jones wrote the 1619 Project. 1619 being important as the year that slaves were first brought to the North American continent. I'm trying to see the match right here. Dred Scott decision said the Missouri Compromise was unconstitutional. 1858 was the year of the Lincoln-Douglas debates. South, remember the South had to ratify the 14th Amendment to be readmitted. Emancipation Proclamation only freed the slaves in Confederate states. Cruikshank. that is the name of a Supreme Court case we didn't talk about, but it was where it involved something called the Colfax Massacre, where blacks seeking the right to vote were killed. The Supreme Court ruled that they couldn't bring their case before the Supreme Court. Remember, it was the Virginia minor case that female citizens can't vote. Remember that the slave trade was able to continue for a period of years under the Constitution. Well, you can make a decent legal argument that neither the Emancipation Proclamation nor the 14th Amendment were actually adopted legally, constitutionally, since the southern states were forced to ratify it, and Lincoln himself said the Emancipation Proclamation he may not have had power to issue. There were no women at the Constitutional Convention. General Fremont, who was the Republican candidate for president before Lincoln was elected, so in 1856, he tried to free the slaves in Missouri at the beginning of the Civil War. Lincoln opposed him because he feared the border states such as Kentucky would leave the Union. Missouri would be another example of a border state that might leave the Union. The 14th Amendment eventually incorporated most of the Bill of Rights against the states. I mean, the states have to abide by them. That's the term that's often referred to as the theory that requires states to abide by the Bill of Rights, and that's called the incorporation of the Bill of Rights into the Constitution. Here's another essay question. In the Lincoln-Douglas debates, Lincoln says, I am not, well, there's a true-false question about one of the quotes that Lincoln made at one of the stops on the Lincoln-Douglas debates. We talked about it during class. Okay, that pretty much covers it. Anybody have any questions?
I do not.
Okay, Joe, I haven't yet put your credit in, I'll put that in. And you all have, there's no end date on this test. You don't have to take it right away. So you can wait till after the holiday. You could wait till the end of the course, although I don't advise it. I think it's better to do it when it's fresh in your mind. But don't worry about it disappearing from availability. It will be available for the rest of the course. And as far as the essays are concerned, I'm not 100% sure there's a space on the D2L for them. I don't think there is. So just send me the essays as emails, and I'll give you the credit. Okay. Thank you, everybody.
Thank you.
Bye-bye.